It looks like both sides have actually turned in all the information needed for the investigation regarding the gag order leak. Let's take a look at the documents. Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. Okie dokie. It looks like even though we are waiting for an order regarding what is going to happen when it comes to the defense filing for a motion in order to delay the trial, we are still also waiting for information regarding the leak of information, the gag order leak, everything that started whenever Dateline came out and said they had all this information. And now we have an order from Judge Hippler saying, hey, we know something happened. We think this side is the one who did it, but we need information from both of you. So go ahead and cough everything over. I need to look at everything. Now we have both the state and the defense's notices of compliance finally filed. Now, right now it is May 28th at around 2:45 p.m. And as you can see, this is the newest list of documents in the Idaho versus Bryan C. Kohberger case. We have a notice of compliance way down here. This was regarding criminal proceedings and notice of trial setting. This portion of this didn't have anything at all to do with the gag order, but I wanted to show you just in case because it does have a similar title when it comes to notice of compliance. But actually what we're going to be looking at is this one. This one is from the state, and it just states simply, comes now the state of Idaho by and through the Latell County prosecuting attorney, and hereby provides notice that in response to the court's document and records hold order dated May 15th, 2025, regarding the gag order leak, the state has lodged with the court for an in-camera review an ex parte letter with attached exhibits. The state has provided the court with documentation of distribution and receipt of the court's order to involved agencies as ordered. And now we have the same thing from the defense. Short, sweet, to the point, comes now Bryan C. Kohberger by and through his attorneys of record, and hereby provides notice that the defense has submitted a letter with attachments for in-camera review to the court in compliance with the document and records hold order, defense dated May 15th, 2025. It looks like they both turned these in 6 days ago on May 22nd, and they're just now showing up on the public interest site. Dang, that's pretty delayed. Now, the next day, the state ended up actually filing a supplemental notice of compliance, and it just says, comes now the state of Idaho by and through the Latell County prosecuting attorney, and hereby provides notice that in further response to the court's document and records hold order dated May 15th, 2025, the state has lodged with the court for in-camera review a supplemental ex parte letter dated the same day, May 23rd of 2025. So they actually have two filings when it comes to evidence. Now, just as a refresher, I wanted to show you guys the paragraph in the order itself that talks about what exactly was needed from both sides in order for this investigation to take place. It states here, it is hereby ordered that all persons who at any time, past or present, worked directly or indirectly by employment, contract, consultation, or otherwise for or on behalf of any law enforcement or prosecution agency engaged in the investigation or prosecution of persons for the murders that are the subject of the instant case are hereby prohibited from deleting, discarding, overriding, destroying, altering, or otherwise making unavailable any, whether electronic or in material form, records, files, documents, metadata, messages, emails, text messages, direct or private messages, phone logs, or logs of communications, regardless of whether made or kept on a work-owned or personal account, device, or messaging app that in any way relate to or document the fact or substance of communications with third persons, including representatives of the media or other persons or entities outside of law enforcement, which communications in any way relate to, refer to, or concern the investigation of Bryan Kohberger Kohberger the facts or allegations uncovered or reported to law enforcement concerning Bryan Kohberger or the investigation into the homicides that are the subject of the current or then potential criminal prosecution of Bryan Kohberger, collectively documents or singularly a document. And when it comes to all of the files and all of the things they wanted records of, they want it specific to the following, but also not limited to: surveillance videos of suspect vehicle 1, the AT&T records for defendant's cell phone, the content of defendant's cell phone and other electronic devices and social media accounts, including internet search history, photographs, and information associated with defendant's Amazon account, or any information referenced in the above-mentioned Dateline episode regarding this case. And just for the record, so that we can also re-clarify, because it seems like some bigger channels and a lot of mainstream channels are lying about the actual intent when it comes to, I guess, responsibility that the court is putting on the state. A lot of people are not being honest, and they're claiming that the defense is the one responsible. I think they just want to think that, but that's not the case at all. And there's nothing they can do about it. The truth is the truth. This one right here is the state's order, and it literally states that it appears likely that someone currently or formerly associated with law enforcement or the prosecution team violated this court's non-dissemination order. Okay, now when we go back and we click on the one for the defense, okay, we go down here and it just states, it appears likely that someone violated this court's non-dissemination order. So when it comes to the one for the defense, it's very vague. It's just, hey, someone did something crazy. I need everyone's information. When it comes to the one for the state, it literally states someone currently or formerly associated with law enforcement or the prosecution team, not someone formerly or currently associated with law enforcement or the prosecution team and or the defense. That's not what this says, and that's really important, and I don't know why people are trying to make believe things that aren't real. Now, other than that, when it comes to new information, we only have this defendant's motion to have the mitigation team actually get to watch the trial. This is something that they had discussed in the actual court hearing that we had earlier this month. It just means that they want the people that might actually be involved in the case, if there is a punishment phase that comes forth, they want those people to be able to watch the trial itself. Because why not? I mean, it's going to be out there for the public, and their job is going to be based off of reality and science. So I don't really see the issue with the mitigation witnesses being able to watch the entire thing. I really don't understand the problem at all. I'll just go ahead and read the very beginning paragraph in the end, because it's really just cut, straightforward. Comes now Bryan C. Kohberger by and through his attorneys of record, and hereby moves his honorable court to amend its exclusion order in this case to permit mitigation phase witnesses to watch the trial. This motion is based on the fact that the evidentiary rules do not apply to the mitigation phase, as this court has previously ruled. Additionally, the purpose of the exclusion of witnesses rule does not apply to the mitigation phase. And then it just states, in the mitigation phase, the witnesses are not true fact witnesses as in the guilt phase. They are not intended to provide accounts of events that are disputed, and thus the concern for tailoring their testimony does not exist. That's exactly correct. While it is unclear that the mitigation witnesses will want to watch any part of the trial, there is no reason to penalize them if they do so. This court is therefore requested to amend its earlier exclusion-related orders to permit them to watch the trial. And like I said, I agree with that. I don't see the problem. That is it for the newest documents. Let me know what you guys think is going to happen now that all of the information has actually been in the hands of the court for almost a week now. Almost a week. Now, I know we had the weekend and we had Memorial Day, but you know what? I'll tell you right now, just plain and simple. If I was Judge Hippler and this situation was as crazy and insane as it was, best believe I wouldn't be able to just relax and have like a whole 3-day weekend. I would be indulging myself in all of this information, because there's no way that I would be able to think about anything else. So I hope that he's that kind of judge that takes it seriously. And I know some people are going to be like, he deserves a break too. Yeah, he does. That's cool. But this is a serious situation. And again, I know that I would be that way, but honestly, he doesn't seem like he even wants to be there. He started his entire presence in this case with this just horribly negative statement, and it's just set the tone the entire time. So honestly, he's probably letting it collect dust, on his desk, most likely. But let me know what you guys are thinking about all this stuff down in the comments. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out. Subscribe to the channel if you are not subscribed already. And please don't forget to make sure that that notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives. See y'all.